I'm attorney Christopher Nicolaysen from Springs Law Group. We're a personal injury law firm, and I'm here today to answer some common questions that are asked after you've been in a car crash. So the first question is, what should I do after I've been in a car crash? Well, here's some pieces of advice. The first thing I want you to do is actually assess yourself for any injuries that you might have, both, externally, if you're bleeding anywhere, have scarring or cuts, and then also just feel generally like through yourself. Did you bang your head? Do you have a pounding headache? Things like that, any soft tissue injuries on the inside as well. And then what I want you to do is call the police and call 911 because you are in a crash, you are not at fault, and you sustained injuries. So have the police come out to the scene of the crash itself. Then after that, I want you to go through and exchange information with the other driver. Remember, when we exchange information, we want to exchange contact info, insurance info, things like that. But we also want to keep things very de-escalated. No fighting, no yelling or arguing. Just a matter of fact, we need to exchange information and do that. If you can't do it at that time, wait for the police to come out and then you can do the exchange of information with a third-party police officer there. Additionally, then too, I want you to grab your phone and then go ahead and take photos of the vehicles. So the damage to both vehicles at that time, any cross streets or anything like that. And then also take pictures of any injuries that you might have as well throughout your body. And so that way too, if you're cut or bruised, you actually have a record now of those injuries too. And then one of the other things too that you can do to help yourself right after then is if there were any witnesses, I would get their contact information as well and make sure at that point that they now have, that you have their information so that they can tell their story at a later date. So those are some things that I would do to start off with if you are injured in a car crash to no fault of your own. So next is, what evidence do I need to actually strengthen my case? So we're going to go back to those things that we talked about in the beginning. You need those photos or video from the scene of the crash itself. Those are going to help a ton. Additionally, if you are able to talk to any witnesses and get their statements, you want to make sure that your attorney and your law firm team can actually reach out to those witnesses because those will be very, very helpful. Because if you think about it, then it's not just a he said, or a she said. It's actually now we have a third party who saw everything happen from the outside and can actually talk about, hey, this is what I saw happen. That person was not at fault. And so that can be a helpful thing to do there too. Additionally, you want to make sure that you get any medical bills and records of any treating doctors that you saw. So that can be anywhere from the emergency room visit or the urgent care right from the day of the crash, all the way through to your preventative care or conservative care like chiropractic, physical therapy, massage therapy, acupuncture, dry needling, and things like that, to even things that can be more severe, such as, surgery consultations, and those types of things as well. So you want to make sure that you have all of those medical records and bills. And then when you go to those appointments, odds are is that you're probably missing work as well. So you want to make sure that you actually can keep a record of your missed time at work. And that will help bolster what we call your lost wages claim. So they don't, you still get to make a claim for lost wages or missed time at work. And you want to think about it this way, but for that crash happening, would you have actually missed work? Would you have used your PTO to go to a doctor's appointment? Or honestly, wouldn't you have actually used your PTO for something more enjoyable than going to a doctor's visit? The answer is probably yes. So you should be compensated for that missed time at work, which is called your lost wages claim. So those are some things that you can do to help bolster or strengthen your case as you have a personal injury case going forward. So should I talk to the insurance company before I talk to a lawyer? If you're talking about the at-fault insurance company, which is the car that hit you, my answer is emphatically no. Talk to a skilled personal injury attorney who can actually help walk you through the process, but also be the one to bear that burden of talking to the insurance company themselves. Remember, in our eyes, the at-fault insurance company, one of their biggest jobs is to try to figure out how not to pay you. Now, alternatively, if we're talking about your own insurance company, remember, you are not at fault. You did nothing wrong. So opening up a claim with your own insurance can actually be okay. That can be an all right thing to do. But if you're unsure, just talk to a lawyer. It's one of the easiest things that you can do. Our consultations are free. There's no charge just to ask us, hey, what would you recommend doing in this situation? And so that's one of the things that we recommend. Third party, don't talk to them. So it should be the at-fault party. Your own insurance, go ahead and do it. But again, if you're unsure, always consult with an attorney. So then when should I actually contact a personal injury lawyer for my case? And our advice is you want to contact them as soon as possible. And we get people here all the time that'll contact us either the day of the crash itself or the next day. And the reason that can be really helpful is we can actually preserve your case right off the jump. We can send out what's called letters of representation to the insurance companies and things like that. So that way, too, you don't have to deal with them. We can now take on that burden of dealing with them day in and day out and advocate for you and fight for you. Additionally, we can also guide you through the process. So I'm a big believer that education is power, and a lot of people have never gone through this process. But it's something that we do day in and day out, where we can help walk you through the process step by step on what it's like to go through a personal injury case. And it's a really comforting thing to know that you've got somebody on your side to walk you through that whole process. Additionally, too, we can also then gather all of your medical bills and records and make sure too that that we're helping you through the right treatment. So for example, let's say you kind of have a schedule clash or you're just not the right personality fit with your treating chiropractor. Well, if you don't want to have that conversation, then as your attorneys, we can have that conversation with them and we can just talk to them and say, hey, what's going on? Or do we need to find a different fit in another place that might be better suited for you and your needs at that point in time? So we're here to listen, we're here to educate, and we're here to guide you through the process as a whole. So how long do I have to file a car accident case in the state of Colorado? Well, that's what we call a statute of limitations. So it gives it until you can file a lawsuit. There is a capped period of time. And in the state of Colorado, for a motor vehicle crash, that's going to be 3 years from the date of the incident or the date of the crash itself. Now, there can be some caveats or some exceptions, and some of those can be things like if you're hit from a government vehicle, the time frame on those are generally much shorter. And that's why it does help to have an attorney on your side who can make the proper notices, which is what we call CGIA notices in those regards. But generally, if it's a basic, what we would call rear end crash or a head on collision or a T-bone crash, then, of one person versus another person, it's going to be a 3-year statute of limitations. So that means you have 3 years from that date. If you wait until after those 3 years, you're going to be barred or you cannot actually file that lawsuit at that point in time. So what if the other driver does not have insurance? And it's a question and a scenario that we get quite often here. Somebody rear ends you, they don't have insurance. So now are you just out of luck? And this is where we tell people to go and check their declarations page of their own insurance. And you want to see if you have what's called UM/UIM coverage, which is underinsured, uninsured motorist coverage. And so that's something that you then pay for to protect yourself if someone doesn't have any coverage or not enough coverage to cover your injuries from the crash itself. So you want to make sure that you go and check your declarations page for that UM/UIM coverage. And while you're also there, I would recommend looking for what we call your MedPay or your medical payments coverage as well. In the state of Colorado, you actually have to sign a waiver to opt out of MedPay. So it's a thing that I would look for too, or talk to your insurance agent about that to see if you have MedPay or medical payments coverage, because that can be a great benefit and value if you're injured in a car crash. So then why do I actually have to open a claim if I wasn't at fault? Well, the reason that you have to open a claim is so that way, for one, you can see if you have medical payments coverage, MedPay, or UM/UIM coverage, uninsured, underinsured motorist coverage as well. And then as well, too, it's going to preserve your rights with your own insurance. And you have a duty to cooperate with your own insurance company because that's who you have to help protect you. So that's one of the things in the state of Colorado that it's very important to do. It is to open a claim for yourself. Now, if you are not at fault for the crash, right, you did not cause it and you had no part in it at all, then too, a lot of people think that your rates are just going to rise up because of that. But if you weren't at fault, that's not the reality. That's not going to happen. And so the insurance company cannot just raise your rates out of nowhere for doing that. They then, by opening that claim, have a duty to keep your rates where they were, but also then too, to help protect you in that regard too, with the coverage that you pay for. So one of the big questions that we get is, how much is my case worth? Because as a civil law firm, we can't just put people in jail because we're not a criminal law firm. So the way that you get justice here is by monetary compensation. So how much is my case actually worth? And we want to talk about what kinds of compensation you can actually get in a personal injury case. And that's going to be economic damages, non-economic damages, and punitive damages. The two big ones are going to be your economic and your non-economic. So let's talk about those for a minute. Your non-economic damages in a car crash case or a personal injury case are going to be things like your medical bills and then they're going to be your lost wages as well, right? Things that we can put a receipt to. It could be things like if you had to get an Uber from one place to from one hospital to another, you could count those receipts as well too. But generally, we're going to see medical bills, potentially future medical costs if you're going to need future surgeries, and then also your lost wages, time missed at work now. And if you have surgeries in the future, potentially time missed at work in the future as well. So those are going to be your economic damages. Your non-economic are a little fuzzier. They're going to be what we call your quality of life damages or your human damages. How did the crash affect you? How are you different today than you were prior to the crash? Do you have some issues like brushing your teeth now because you have a shoulder injury? Did you miss events because you had to go to appointments instead? Did you, was your sleep off? Are you somebody too that was planning to run a marathon and now because of a leg injury, you can't do that? So those are really important things to talk about and to think about as you're going through your personal injury case, is those non-economic damages, quality of life, pain and suffering, inconvenience, things like that is the way that I want you to think about those. So those things are valuable. Just because we don't have a receipt to those, it doesn't mean that you shouldn't be compensated for it. Remember, but for this crash happening to you, your life would still be pretty normal and you'd be going about your day to day. But this crash decided to inject itself into your life. And now you had to switch everything up and you can't do the things the same as you could before the crash. So that's how I want you to look at non-economic damages. Punitive damages, a little different, very few cases, but there are going to be ones too where we have things where the at-fault driver was reckless or grossly negligent. Think of something like drinking and driving, things like that, where they broke a law and then still crashed into you. So that is kind of the way that I would have you think of those. Primarily, the two main ones that we see are economic damages and non-economic damages. So one of the questions I want you to think about too is, can I still recover damages if I wasn't wearing a seatbelt at the time of the crash? And the answer is yes, but. And so, yes, you can still recover damages, but they're probably going to be a bit lower than they would have been had you been wearing your seatbelt. Think about it this way. If you had been wearing your seatbelt, would you have actually gotten the injuries that you sustained from the crash itself? The seatbelts are there to protect you and something that we're required to do by law. And so by not doing that, you now potentially caused some of the injuries by not actually wearing your seatbelt. And so what the insurance companies may argue is that, you know, because you weren't wearing your seatbelt, your injuries were worsened because of that. So they may decide to give you a lower amount. There's some other legal pieces that come into that investigation side of it, but ultimately just understand if you weren't wearing your seatbelt, you're still entitled to compensation. However, it may be reduced. So how long does a typical car accident case take to actually resolve? And again, just like any lawyer answer, the answer is it depends. It depends on the facts of your case and your injuries. So one of the things we want to make sure we do here at Springs Law Group is we're not just rushing your case just to get an outcome. So we want to make sure that you get the proper treatment so that you can heal up and get back to as close to the person that you were right before the crash. So we don't rush cases just to rush them. If you have minor injuries, honestly, those are going to settle much faster than a case with severe or catastrophic injuries. Now, sometimes too, depending upon the other side and the insurance company, it may be a case too where they actually don't give you a good offer in negotiations, and we do have to file a lawsuit. When we file a lawsuit, those cases are definitely going to take much longer than if we just negotiate and come to an agreement. So again, just like any lawyer answer, how long is your case going to take? It depends. So I'm injured in a car accident and I retain an attorney. Does that mean that I actually have to go to court? And the answer there is no. And so it doesn't mean you have to go to court. You may end up going to court, but it doesn't mean you have to. And the way that I want you to think about it like this are these two sides. One of them is what we call pre-litigation or before filing a lawsuit. And that's where we're going to work your case and actually try to negotiate with the at-fault insurance company. So that's pre-litigation. However, if we can't come to a good settlement or a good agreement, that's good for you as our client, then we will recommend filing a lawsuit. Filing a lawsuit means potentially you could go to court. Court, though, or trial, is ultimately going to be one of the last resorts because even after filing a lawsuit, there's a lot of stuff that goes in play after that. It's going to be things like written discovery, depositions, mediation, and then ultimately, if we still can't come to an agreement, even after doing all that from the lawsuit standpoint, then we will go to court. And so, does it mean that you'll have to go to court? No, it does not. And you may, but it depends on the facts of your case and what the conversations with the other side is going on. How do I handle my medical bills though while my case is pending? And so it's a question we get often is what exactly do I do and what's the process here? And again, at Springs Law Group, our job is to advocate for you and to educate you. So the first thing we want you to do is make sure that you're using your health insurance if you have it and if there is a place that will take it. Additionally, we want to check your declarations page and see if you have MedPay or medical payments coverage as well, because we want you to use and apply that to your medical bills too. Then what we're going to do is set up what we call a lien with the medical or treating provider. So that way too, they can actually get paid out of the final settlement amount at the end of the case, instead of having to make payments continually as you're going through treatment. And so that would be an agreement through the case itself. But those are conversations that we would have upon hiring, and we would talk to you and walk you through that piece of it. But just don't worry about, the bills in that sense. What we want you to worry about is treating and getting better, following the recommended treatment of those doctors who are working on you and making sure that you're being consistent and walking through all that. So how much does it cost to hire a car accident lawyer? The thing I often tell potential clients when they call in is I want to go through these 3 different types of pay structures. So I want you to think about a retainer fee. So that's one that we see often in like a family law case where you put down a retainer and then the attorneys bill at an hourly amount. That's not what we do here at Springs Law Group. We're a personal injury law firm. And then next is a flat fee, which is, you see that a lot in like estate planning, where you put down a flat fee or a certain amount, and then they'll make do your wills and trusts and things like that. Again, not what we do here at Springs Law Group as a personal injury law firm. So then lastly is what we call a contingency fee. So then what happens there is we actually take a percentage of the final settlement amount. Now, so let's say your final settlement amount is 0 and you get nothing. Then what is our fee? Our fee is 0. So we do not get paid unless you get money in pocket, because we also have it written into our fee agreement too, that we will never take more in our fee than your net recovery. So we don't ever want to be a creditor to you as our client or do anything like that. It's not our job to have a good client relationship, but sit there and go, well, you got nothing, but you owe us money. So that's not really what we're looking for here. Our hope and our goal is we work really, really hard to build your case up, get you the most possible, because then obviously everybody does better. So that's how it works there. So will you handle all aspects of my case? And the answer there pretty simply is yes. We will do everything except get the actual treatment, which we need you to do. So our job here is we're going to set up your case file. We're going to inform the insurance companies that they are to talk to us, and then we will relay that information to you. And then we can set up your request and get your medical bills and records once you're done treating. We'll get all copies of like the police report, any witness statements, basically build up your whole evidence file in that regard as well. And then at the end of the case, after we work settlement with you, then we can also work on negotiating the liens down from those medical providers too, and ask for requests from them. Some of them do it, some don't, but to ultimately lower down those medical bills and costs as well. So those are some ways too that we take care of all aspects of your case. And additionally too, one way that we do it is through communication. So a lot of people want to know, how do we communicate with our clients? Well, we do that in a variety of ways. So we do that through texting. We have an app that we use where we text our clients and they can text back to us. They can send photos, they can do anything like that. We want to make it as easy as possible. If a client doesn't text though, we're happy to meet in person. They can come into either of our 2 offices and meet in person with any of our team members, their paralegal or their attorney. Additionally, we'll do 2-week checks whenever clients are treating, which we're just going to text in and see, how are things going? How's treatment going? Is there anything that has changed in your treatment regimen that we should know about so that we're up to speed on what's going on? But the other reason too that we do those 2-week checks is we want to be an accountability partner for you. So if you're just kind of like, I'm tired of these appointments, I don't want to do it, and you start no call, no showing, that can look really bad. And we want to kind of stop that before it even gets started. So that's why we're going to do those 2-week checks, because we don't want to have a gap in treatment or a gap in care, because that could really hurt your case in the long run. So communication for us, it's essential. And also too, if you ever want to get on the phone with one of your attorneys, you just reach out to the paralegal, ask to get on their calendar, and they'd be happy to chat with you.